aware of. For example, we, if anything ever changes in the law, give out big notices to our clients that say, hey, this probably impacts a lot of you, laws that have changed. So come on in and talk to us. But all right, so welcome everybody. I'm Attorney Justin Randall here with Hooper Law Office. Just a quick couple reminders before I go too in depth here, but if you're participating via Zoom, you can ask questions as you're watching this. I can see them pop up, so I'll be able to answer them as I go through things. One other thing too is we do have initial consultation forms that you can fill out at the end of this. They will let us know if you want us to reach out to you. They provide some other areas for feedback, things like that, if there's any topics you want to hear us talk about. So those feedback forms are where you would fill out that you do want an initial consultation. If for some reason you need your plan reviewed, or you already have one in place, but it's been a lot of years, that's the kind of thing where some of the things we're going to talk about today are the types of things we could talk about during that initial consultation or plan review. They are complimentary. They don't cost you anything to come in and talk to us. So we usually schedule them for about 2 hours. If for some reason they take longer than that, we can go longer than that. Sometimes they don't take quite as long. So just be aware, they are free of charge to come in and talk to us. We really need to get to know you guys and know your family and figure out whether that plan is the way it's set up is the right plan for you, or whether things need to be changed. So, okay, so our topic today is we're talking about law changes and how they can impact someone's estate plan, right? So I'll talk about a couple specific ones that have changed, but I won't go through the entire list of law changes I have here. We'd be here for quite a while, but if you are signed up in advance, you'll actually be getting this list as a handout material. So you'll be able to see some of the dates and when these things change to know if your own plan that you may have is impacted. But in general, laws change relatively frequently, sometimes more frequently than others, depending on the area of law that it is. Estate taxes in particular, those exemptions have changed quite a bit over the last 20 years, right? They've gone from pretty low to pretty high, to where 1 year where we had no exemption at all, and no cap even. It was just, there was no estate tax because they forgot to re-up it and they let it lapse. So things like that can change, and it's something to always be aware of. But the general public, you as clients are not supposed to be the ones keeping track of these sorts of things. You're not supposed to be the one who makes sure that your plan is up to date, or knows exactly how a law change is going to impact you, which is why it's so essential, though, to have annual reviews sometimes, or maybe every couple of years have some reviews where you meet with your attorney who drafted your plan and you ask, okay, nothing's really changed in my life, maybe, or maybe some personal things have changed in your life. But on top of those, has anything in the law changed? Is there anything in my plan I need to be aware of that is now impacted by a recent legislative change? Like I said, you're not supposed to be the ones who are aware of those things or know exactly what you need to do. That's where people like me come in and help you get those plans up to date. So these types of law changes may be things like legislative changes that deal with the entire code of a law being rewritten. So, for example, I feel like, 2014, I believe, is when Wisconsin adopted the Uniform Trust Code. And that is something that then changed all the citations for our laws for dealing with trust and estates. So maybe your plan is old enough where it has the old citations. That won't invalidate it, but it will make it harder to follow if someone, 20 years from now is looking at it. They might think, well, that's not the law I'm used to seeing. And they have to then go, oh, okay, this was prior to the law change. Another can be tax implications. There are tax laws that change all the time. There are, whether that's income tax laws, or a very recent one that we had is something called the Secure Act. So the Secure Act in particular impacted how inherited IRAs work for most beneficiaries. So except for a few exceptions, most beneficiaries now, other than spouses, so like if you're leaving your assets to your kids, for example, at that point on a second death, and that's where the IRA is going, most beneficiaries have a maximum of 10 years to take out those distributions. Now they have to liquidate the account by the end of year 10. So that has impacted a lot of plans, because the way a trust, for example, might have been set up in the past prior to this law change, which occurred at the end of 2019, we might have set it up where, hey, we're setting this up to deal with like required minimum distributions and using the life expectancy of that beneficiary. Well, with this law change, the life expectancy for most beneficiaries doesn't matter anymore. So that plan, not that it would be, invalid, or it wouldn't necessarily function as an estate plan, but it wouldn't be the most tax efficient anymore. And so after that law change, we tweaked how we draft our documents to deal with it. So sometimes it's not a catastrophic failure, right? It's not something that, hey, this is totally invalid after the law has changed, but it's something that you want to make sure your plan works the way it is intended to work, or the most efficiently it can work. So the most important thing that you can do when making sure that your plan is up to date is really just scheduling regular reviews. What I mean by that is, most attorneys, estate planning attorneys in particular, will say, hey, come in every couple of years at least, talk to us, let us know if anything's changed in your life, but also make sure that, on our end, the law hasn't changed. If something is impacting you, or maybe we have this perfect plan that looked great at the time, but now it's the most inefficient because of a law change. That can happen too. So those regular reviews is when those things would be caught. It's something I can look at some of these documents and say, oh, this is prior to this law change is when this was drafted. It really isn't set up to deal with the new law at all. So let's add this provision here, or let's tweak this so that it works the way that you would want it to for your kids, in a tax efficient manner, or in maybe an asset protected manner for them. So there's different ways that you need to be, you can deal with these law changes, but you are not the ones who would be aware of them without talking to your attorney. So estate taxes is a really big one. I'll talk a lot about that just because that is the one people tend to be concerned about the most. But for example, somebody's estate plan that may have been drafted in, say the late 90s, maybe mid to later 90s, might have been specifically designed to deal with the estate tax at the time. So there might be very specific planning that deal with maximizing the personal estate tax exemption on the first death, or are more complicated because they were dealing with a very small estate tax exemption. I believe it was in the neighborhood of about $600,000 per person back then. So a lot of people had taxable estates, or a lot more than today. And a lot of the plans you see from them specifically deal with those concerns, because that was what you needed to be aware of at the time, what a lot of people had concerns about. So a lot of trusts from that time period have estate tax planning in them. Well, that might be completely unnecessary today. So this is actually an example of where things might have gotten simpler for a lot of people, because maybe they don't have a taxable estate under the current exemptions. To give you an idea, the current estate tax exemption is $11.7 million per person. Wisconsin does not have its own state estate tax. We use the federal one only. But there's a huge difference between if you were doing taxable estate planning in the 90s and you had maybe a couple $1 million and you were over the $600,000 exemption back then. But now, most people don't have the size estate that meets that level of, being a taxable estate for estate taxes. I believe it's less than 0.1%, maybe something in that neighborhood, that have a taxable estate these days because the exemption is so high. So you might not need as complicated of a plan anymore that you had back then, just because the law has actually simplified things for you. However, there are times, like with the Secure Act, the change to retirement account laws, and how they are dealt with when a beneficiary inherits those accounts, that may have made things maybe a little more complex, or things that you need to be aware of that you need to tweak in your plan, because it was very straightforward at the time. We're gonna just have everything go to them, but now they have a huge tax increase that they're going to have because they're taking it out at a faster rate. This would be if it's a traditional rather than a Roth IRA, for example. And sometimes with these legal changes, it's not so much, or it's not only about updating your documents, but it's about talking with your advisors in general, right? So on the legal end, you'd be talking to your estate planning attorney. They would hopefully point you to your CPA and your financial planner to talk about, okay, with the increase in taxes that your kids are going to have to pay due to the quicker payout of an inherited IRA for most people, what can we do to deal with that? I still, on a pretty regular basis, when I'm talking to either new clients or during initial consultations, will ask if people have heard about this change. And a lot of people say, oh, no, I didn't hear that. Or maybe they heard about an aspect of it, right? But not the entire thing. And that's to be expected. It's our job to stay on top of that, not the client's job. So when they come in and they're coming up with these questions about, well, how do we deal with that? That's what we're here for. So that is why it's so essential to come in and talk to one of us about legal changes. Okay, so is it just wills or trusts that you need to be worried about, with legal changes? Can it impact anything else in terms of your estate plan? So we often talk about, estate plans are not complete unless they have, or they include a power of attorney for finance, power of attorney for healthcare, HIPAA authorizations, and living wills. So there are legal changes that impact those as well. For example, in 2016, Wisconsin passed a law called the Digital Property Act. You don't need to know anything about it, really. It's just the point is that this changed back then. And we had to update our financial powers of attorney to include or incorporate aspects of that law so that somebody's financial power of attorney could have access and use all of the benefits of that digital property law, and have them at their disposal so that if they needed to step in and act as someone's agent, they could do so with digital property as well. Things like passwords or online accounts, or I suppose very timely, maybe cryptocurrency even today, right? So that was a big law change that we needed to incorporate. And if somebody has a power of attorney from prior to 2016, I might say, all right, let's, we definitely want to get this up to date. Let's get the new language in there. There are things that are going to be beneficial to you. So there's aspects like that with financial powers of attorney. Another could be maybe requirements have changed since the last time somebody came in, right? Maybe certain things that you were allowed to do at the time, you're not allowed to do now. And so an updated document needs to be tweaked to deal with that. A really big thing I see with the financial powers of attorney is maybe they were set up when the Medicaid rules, for example, were completely different than they are now, and they don't have the authorities that somebody would need to do long-term care planning for their parent or their loved one through that power of attorney. So sometimes it's not so much does it make something ineffective, but are there things, that you can do to make those documents as effective as possible and as useful to you as possible? We always sort of jokingly say, but it's also very true, say that financial powers of attorney are only as good as the authorities they expressly include. So if something is not stated in there, but maybe the law has allowed us to state a new authority, you might want that in there for your own sake. Or if you are the power of attorney agent, you might want to talk to your loved one about getting that up to date for them. Okay, so a really, really big one too that changed in about 2013 is when Wisconsin changed its Medicaid rules. So in 2013, they expanded what's called a state recovery, right? And this is when Medicaid, the state Medicaid program, comes in as a creditor to someone's estate to potentially attach a lien against the estate, or maybe they already have a lien on the home, and they take what some of the assets away from the estate as a creditor because they provided support for that person's care. So they keep a running tab essentially of, okay, we paid $20,000 for this person's care. I'm going to take that bank account worth $20,000 to recoup our expenses. So it used to be, prior to this law change, that a revocable trust was exempt from estate recovery. Well, prior to that law change, that was true. After it came about, new revocable trusts that are drafted after that date are no longer exempt from estate recovery. So it's important if you potentially have an older trust that was prior to that date to know that you are grandfathered in and that it is not necessarily automatically available for estate recovery. But it can raise the question at the time of dealing with estate recovery after someone's passed, if updates have been made, are you opening things up to that potential liability? And so you want to be aware of the law changes. You want to be aware of how they impact your plan, especially things with long-term care. All right. So I'm not seeing any questions, so I'll just keep pushing through, but just as a reminder, you can definitely ask questions if you have any. All right. So the big change that occurred on top of the last couple of years, in addition to the Secure Act, was for veterans. A veterans law change, a veterans administration law change occurred or their rules changed rather, where it used to be for the improved pension program, sometimes called aid and attendance by a lot of people, whereas it's a pension benefit that a veteran can receive directly to their bank account, tax-free. It can be used to supplement income or supplement care costs. It can be a lot of things, but they also have asset limitations. Well, planning we would do prior to this rule change, you could get someone qualified overnight. You could potentially, they didn't have any sort of look back like Medicaid had, like the 5-year rules that you've heard about. They didn't have anything of that nature. So, you could get someone qualified overnight. Well, now plans done after that date, there are look back periods that you do need to be aware of. So just like Medicaid has a 5-year look back, the VA decided they're going to use a 3-year look back period. So what this means is if you do anything in the 3 years before you apply for this benefit, that can impact eligibility, right? They can give you a penalty period for the time or the amount of assets that you gave away if it helped you get qualified for that benefit. So the planning has changed there, and plans prior to that date are not impacted by that, but plans after that date are. They also gave us new rules on the assets that someone's allowed to keep. For example, they tried to match it with Medicaid, and of course, it's already slightly different because they used a different inflation factor on it. But now it's about, this year, it's about 130,000 that a veteran is allowed to keep, regardless of whether they are married or single. That is not including the home. The home is exempt as long as it has no more than 2 acres surrounding the property. So, and there are some exceptions to that, but that's the general rule. Prior to that law change, it was this nebulous kind of, it shouldn't be more than this, but it could be within this range. But there was no set number that someone was allowed to keep. We just had to sort of use best judgment based off of kind of guidelines that they gave, but not specific rules. So sometimes with these law changes, the importance of coming in and talking to one of us is not so much, okay, is this actually going to impact me, but making sure you're getting the right advice too. I can't tell you how many times somebody will say, oh, I've heard this has changed, or I heard like Medicaid now has a 7-year look back rule, even though that's not actually true, and there's not even talk of them changing that, right? It's just someone read something somewhere or heard it from a friend, and that advice, while well-intentioned, can be dangerous to follow because it's just incorrect. So a lot of times with updating your plan or keeping up with these legal changes, it's not so much making sure that your plan is as effective as it needs to be. I mean, that's a huge important part of it, but it is not the only part of it. The other aspect of it can be, what do I need to be aware of if I'm having these types of concerns? If I am worried about long-term care and I am a wartime veteran, what can I do to protect myself or to get some assistance in paying for care? Googling things is dangerous. So if you get the old rules on Google, you might be unfortunately relying on things that are out of date. And that doesn't help you out. That doesn't help your family out. And that's where coming in and talking to one of us can be very helpful for that, because you can get the up-to-date rules. You can understand what you need to do to plan. And if you, like I said earlier, if you do already have a plan, you are more than welcome, even if it was drafted by someone else many, many years ago, you're more than welcome to have us take a look at it. That's where that initial consultation becomes very valuable. All right, so little bit of a shorter topic today, but one thing I want you guys to be aware of too is our topic next week is going to be a very interesting one. It is Medicaid and gifting rules and what things you need to be aware of if you're trying to plan for long-term care in general. The topic is about a lot of people will hear things like, oh, I'm going to gift things over to my kids to get it out of my name and protect it from care. And actually, Peter Harbach, another attorney in our firm, is going to talk to you guys about how that can be very dangerous to do without getting advice first, and the types of pitfalls someone might run into with a gifting strategy. So with that, I am going to let you go because I'm not seeing any questions. But if you do have any questions, feel free to reach out to us. Please feel free to fill out that initial consultation form. Remember, those are complimentary. They don't cost you anything to come in and talk to us. And I hope you guys have a good rest of your day.